Massachusetts. Court is now open. You may be seated.
Ms. Dean Smith. Good morning, Chief Justice Marshall, Justices. May it please the Court, my name is Karen Dean Smith, and I represent the defendant appellant, Mr. Joshua McKinnon. The focal point of this appeal is the Castle Law, more specifically the refusal of the trial judge to give a Castle Law instruction to the jury when requested to by defense counsel. And since counsel did request it, citing chapter and verse, that was General Laws Chapter 278-8A, then the judge refused, but stated specifically that the defendant's rights were saved. In that situation, it is not necessary to have a post-charge objection, and the standard of review is prejudicial error. Now, the defendant was convicted of assault and battery with a dangerous weapon.
Can I just get your sense of the big picture? Is it your position that a dwelling includes the curtilage?
Yes, Your Honor.
And so anywhere within that footprint would be considered the dwelling?
Not necessarily. The curtilage is a mixed question of law and fact. Of law, that the dwelling includes some aspects of curtilage, yes. Of fact, the extent of that, the boundaries of the curtilage, is a question of fact which should have been submitted to the jury, especially when, in this case, it was an attached appurtenance where the evidence was not only most favorable to the defendant, but also from some of the Commonwealth side, that the incident, the fight took place on the porch and then on the ground next to the porch.
But at least you agree that the fight did not occur in the house?
It did not occur in the house, but also I would submit that there is no evidence that it occurred in the driveway, contrary to the Commonwealth's position. Because even Mr. Morey, who distanced himself, his testimony distanced himself most from the house, and his was the only one to so distance himself, said he was 5 to 6 feet away from the car when the defendant came at him, and that then the tussle took place so that he was on the ground. Other testimony, Derek, the son...
Well, let me just stay with that for a minute. Mm-hmm. Are there any cases that have said that outside of the house is considered the dwelling?
Yes. In other jurisdictions, actually, it's most jurisdictions extend in the Castle Law situation to the curtilage. There are some that restrict it more, instead of open areas within the curtilage, will restrict it to an attached appurtenance. Michigan is one example of that.
Well, you're really asking... Are you done? Oh,
No, I just have one more question. So your position would be, in the yard would be considered part of the dwelling and covered by the Castle Law?
It could be in the circumstances of the case, but it's a factual determination for the jury, because so much depends on the physical the layout of this house, which I can describe in a minute, but I think Justice Cowan had a question.
Well, you're asking us then to at least extend our case law so that we would, in effect, back up the Castle Law. And now it would be not only if there is an attack in the house or an intruder in the house, but to someone whom the defendant sees coming toward the house.
It isn't an extension to include a porch as part of the curtilage.
Well, so far we've only included in the Castle Law something from the door in. Would you agree with that? Our cases?
No. Because
have our cases interpreting the Castle Law ever been applied outside the front door?
Yes. The Commonwealth v. Albert said, in the case of a multi-unit residential apartment building, which is a more obviously restricted situation than in this case, with a house in a rural area and a single ownership, that would include an apartment plus separate areas.
But that's still within the front door of the building. It's still within the building.
It didn't define what those separate areas would be.
Okay, it wasn't any place outside the front door of the building, though, was it?
It didn't define that. It said common areas under the,
But a
so
common
if it were
area
storage area, for example.
But a common area is generally inside. Can you think of a case in which a common area is outside the house?
Yes, if there were, some place that may have been.
Condominiums.
Condominiums.
As they have in apartments, place where people can congregate.
Yeah, condominium owners, two condominium owners could get out to their front yard. They would both be entitled to the castle law. They could kill one another, and they'd both, or one of them could kill the other, and it would be entitled to claim the castle law. Doesn't matter who claimed it.
Well, I don't know if there, I haven't had any case where two condominium owners killed each other. But what the common ownership, the property, obviously, ownership, is not decisive in this matter. It's occupancy.
Are there any special rules of construction that might be applicable here? The usual rule, of course, is that if it's a penal statute, you construe it strictly in favor of the defendant. Here is one where a defendant gets a defense. So is that subject to any special rule of construction if there's an ambiguity, so to speak?
Well, there's not any ambiguity in the sense that dwelling, if we're looking at the construction of the word dwelling, and we have cases on this, dwelling is, since the legislature did not define it, it takes its common law meaning.
Right, but they also use the phrase in his dwelling, not
They do.
on his property. Or, it seems to me, one of the problems that you have is if the legislature meant what you're trying to say, the simple way to do it would have been to say on his property. And they didn't. They go in, suggesting you've got to be inside something, not just on something, not just near something, but in it. That does, to me, connote inside. There's got to therefore be something that you've got to be inside.
Well, if you use a term like property, that's very expansive. And the focus of this is habitation. And that is the habitation and the proximity to the house and the purpose.
It seems to me the purpose is that once you're inside your own home, i.e. where you can be behind locked doors, you don't have to abandon it, as part of a retreat. But it seems to me if you're outside your home and you're being attacked, it's still rational and reasonable for the legislature to say, well, you still have to retreat into your home. Once you've gone there, then you can draw the line, and you do not have to retreat any further once you're in your dwelling. This is about the obligation of retreat, right?
Well, yes, but nobody has so restricted the dwelling to exclude, for example, an attached appurtenance.
But it's a
But then
bright...
you're inside something.
Yeah, it seems to me that the purpose of a bright line rule here is to let homeowners, let dwellers know that, with certainty, that once they're within the walls of their home, they are entitled to, they are not obliged to retreat. But once you start incorporating concepts of curtilage, which is sort of a floating concept, you don't really know what your rights are.
But that's a factual determination for the jury.
But when you think about the policy of the law, and we know quite clearly that the purpose behind the statute was to protect a person within his or her home, so that, as Justice Sawson mentioned, there's no duty to retreat once you're within your home behind closed doors. The policy of the statute wasn't to permit you to race outside your home and protect you when you attack someone who's outside.
Well, the policy is, of course, to preserve the sanctity of this home. In this case, in a comparable kind of case, only it was burglary, armed burglary. Burglary has historically been a defense of habitation. This court, I believe it was Commonwealth versus Rowland, actually analyzed a kind of situation like this, where attackers, there is no question, if I could just talk briefly about from the facts, that it's undisputed that Mr. Morey, Sr., came with his two sons and a friend. at 1 in the morning, unannounced.
But for a burglary, you have to break the clothes, and that...
No, but this was for the predicate, the killing would have, under the statute, would have taken place in the dwelling. And they said under the factual circumstances of that case, when there's first an attempt to lure the person out, as there was here with Derek, then when that didn't work, when Melissa said leave and was going to close the door, then Mr. Morey came out in a rage, coming up the steps, with the obvious intent of you saying, someone's hit my son, and someone's going to pay. You're going to pay. And if you don't come out to the defendant, I'm coming in.
Well, he doesn't give up the right to self-defense. He's just giving up the obligation to retreat once he steps outside his house.
I don't think he is giving out the obligation to retreat in that case, because it is still, in the Rowland case, the court held because of this lure, because of the attempted invasion, because the sole purpose was retaliation, that under those circumstances, even though the killing in that case, in the Rowland case, took place in the hallway, and that was a common hallway, that the court said under those circumstances, it didn't matter whether the killing was inside or outside.
Was the defendant... Oh, go ahead. Was the defendant and his friends prevented from closing the door and calling the police?
What happened is, when Melissa told Derek to leave, she couldn't see who it was till he came up close. And there are many instances, I'll be happy to point them out, to indicate that this did take place on the porch. When she told him to leave, she went to shut the door. At that point, Mr. Morey came up, as she said, in a rage, and was running up with his arms raised and with what she thought was a weapon, saying, someone's going to pay. If you don't come out, I'm coming in.
Okay, so what
And at
prevents
that
anybody
point-
from shutting the door in his face, slamming the door in his face, and calling the police?
I think, well, at that point, the defendant came out, because at
Right,
that
but
point...
isn't that the whole line that the statute was designed to protect you when you're in your house? He then could slam the door and call the police.
The testimony that there were two doors, screen door and a regular door, and the jury could make an inference that there simply wasn't time. She was going in, and did call the police, and the defendant came out to prevent,
Came out.
because the threat was clearly that they would force their way in. And to prevent that from happening and the greater risk of harm, that's when the defendant came out.
Right, but, so he still has, as you said, all of these self-defense claims for the jury to hear and sort out. But it certainly does seem odd to say that you have that the no obligation of retreat means that you can leave the comparative safety of the inside of your home to rush out and do battle.
Well, first, the evidence was that he didn't rush out. He came out and held the bat to his side and told Mr. Morey to leave. Then there was an argument. Mr. Morey was enraged, and at that point, when his hand was raised and when Melissa thought saw that he wasn't going to go away, that there was to be a fight, she ran to the telephone.
But isn't it still, even as you're describing the facts, it was his choice to leave where he clearly could be protected?
I don't think it's a choice when the threat is to come by a man who is twice his age, a big man. The jury could infer that he knew that he had already been convicted of assault and battery on a police officer.
But you're arguing self-defense. Let's focus on the obligation to retreat. It seems to me that when you're in the house, when you're in your house, there is no place else to retreat. There's no place else to go. And
Yes.
Of course, you could always leave the house, but you're exposed to greater danger. The person should not have to leave their house. That's the ultimate sanctuary. But once you're outside in your front yard, why isn't that the same as being out on Main Street?
Well, and certainly in this case it wasn't.
So he has available the principle of self-defense.
He has but we don't know, because the judge emphasized the duty of retreat, because he, as a matter of law, excluded any aspect of curtilage, which is certainly not our common law, which is certainly not the construction given by our cases. Because he excluded that totally, the jury did not have not only any possibility of finding as factually that attached porch where he was and the fight was part of his dwelling. Because of that.
We have crimes of armed assault in a dwelling.
Mm-hmm.
Don't you have to be in the dwelling for that aggravated felony to occur?
Well,
can you be on the curtilage?
Except in the, as I was saying, in the Rowland case, they did analyze that statute required the assault of the person to be in the dwelling. And they said in that case, they didn't discuss curtilage, but they said because of the circumstances of luring them out with the threatened forced assault into the house, that where he was killed it didn't matter that he was killed in the hallway.
Yeah, but a hallway, again, is not a front yard.
No, but it's a common hallway, which are, for purposes of the castle law, has certainly been, in our cases have said a common hallway is not protected by the castle law.
Thank you, Ms. Jean Smith.
Oh, thank you.
Ms. Lugo?
Thank you. May it please the Court. Kimberly Rugo, Assistant District Attorney for Middlesex. Also with me is the trial prosecutor, Assistant District Attorney Melissa Conroy.
Did any of this occur on the porch?
No, Your Honor, absolutely not.
Well, can we just take a look at at least in the reply brief, right before my brother stepped on the first step, that's from Mr. Morley.
That's correct.
So let's
Yes.
assume, for purposes of this discussion, that there was some activity on the step of the porch, in other words, not in the driveway.
Okay.
At least for my purposes, that would be helpful.
Okay.
I mean, it seems to me that Bennett has taken care of the driveway. Commonwealth against Bennett, correct?
Well, even if we assume that the victims had reached the porch and were on the steps, there is absolutely no basis in the facts of this case or in reading the statute to extend the dwelling, the definition of dwelling, to a porch. Defense counsel cited other states which have extended a similar statute to attached porches, and in those states, generally speaking, they will specifically cite in their statute attached appurtenances. I believe she referenced Michigan. In their castle law statute, I believe they specifically list in a dwelling or attached appurtenances.
So your argument is even if this porch were, say, an enclosed porch, it would not be covered?
Well, no, not necessarily.
Okay. So it's a porch that's not enclosed?
Well, if the structure has the enclosed and secure qualities of a dwelling, then potentially that, and a defendant raises, and there's evidence to suggest that the structure does have those qualities, then potentially that's enough to, and all the other requirements of the statute are met, potentially that's enough to at least have the instruction given.
Okay, so your position would be, today, there are many houses that have enclosed their porches. What used to be porches is now an enclosed area with a door there. So an enclosed porch like that would be part of the dwelling, under your argument?
I think that if we have to stick to the usual and accepted meaning of dwelling, a place of habitation where a place that is used for someone to reside.
If you commit a breaking and entering onto the porch, you're in the dwelling.
I believe that's just about correct, Your Honor. I mean, I guess you have to be more than just actually breaking and entering. You actually have to, for breaking and entering, you could wave your arm through the plane of the threshold of the doorway, and that would be enough. You're inside for that moment.
But that wouldn't occur in an open porch.
No, Your Honor, absolutely not, which is, there's no evidence to suggest.
If there's a valuable object on the porch, and the defendant is on the steps, reaches over the rail, and grabs the valuable object, you're saying?
I'm saying I don't believe that that's enough to charge breaking and entering.
Right. You'd adopt the same definition as we've adopted for breaking and entering in a dwelling.
That's correct, Your Honor, except for the fact, obviously, this Court has already said that common areas would constitute being in a dwelling, common hallways in a multi-unit dwelling would constitute a dwelling for purposes of the burglary statutes and the like, but would not apply, obviously, to the castle law defense. So the core definition of dwelling remains the same. the enclosed and secure qualities of a dwelling, a place where someone resides. So in this case, there is absolutely no basis whatsoever to extend the definition.
If someone were to get up in the middle of the night and see that people were on their porch, their private porch, about to break into their home armed, would they not have a right to use reasonable force to resist that at that point? They'd have to remain in the house until they broke in order to take advantage of the castle law?
Well, a person does have a defense of property to the extent that they could use reasonable force to, eject a trespasser from their property. The question, so if the crime is against the property, then so be it. They have.
Well, how's one to know if there are armed people on your porch in the middle of the night, whether they intend to just break a window, steal a wallet, or
they're just there?
Well, I suppose it's a question of what the person inside the house reasonably believes is about to happen. Is he under the reasonable belief that he is in serious?
I'm in some rural isolated place, and I wake up in the middle of the night, and there are 3 men on my porch. I have no idea what they're planning to. I can do nothing.
You have the benefit of the protection of your castle. You have the sanctity.
I can do nothing.
No,
Call the police.
you can.
Let's assume the
You can
police
still
are
have
miles away.
self-defense on those facts because the circumstances, the house is surrounded and you're outnumbered, that you don't have anywhere to retreat to, and you're not safe in the home against those numbers and those. I mean, you still have the full self-defense.
Well, assuming that
But
I
you still
wanted
have the
to-
obligation of retreat, but there may be nowhere to retreat to under the facts, it seems to me.
But my hypothetical is there are 3 people out on the porch, right, in the middle of the night. Let's assume it's a rural area. The police are a long way away. It's going to take a long, and it may be volunteer police, whatever. Assume that calling the police is not a reasonable way to assume that they will leave. What can I do under your? They haven't attacked me. I'm in the house.
I'm sorry, did you say calling the police is not reasonable?
Well, calling the police isn't going to protect you in the next 10 minutes.
They're not going to get there fast enough. I don't know what they're doing. They're out there. I see one of them strike a match. Maybe it's to light a cigarette.
Well, I suppose there's nothing to prevent you from walking out onto the porch and asking them to leave.
Isn't that
sorry. And then if they don't, it's not self-defense now, and they don't leave, so that nobody, I want them to leave, they say no.
At that point, they become a trespasser on your property, and you can use reasonable force to get them to leave. So
Well, the castle law wasn't designed to get people out of your property. It was designed to eliminate the duty to retreat in case somebody came after you.
that's exactly right.
Yes,
Your Honor.
yes.
This
So
is a
now
question
I'm out on the porch, right? Now I'm out on the porch, and one of them comes at me.
And then I would argue your duty of self-defense, your self-defense principles apply, because when you go back and think of the purpose and policy of the statute, it was passed only in 1981. So up until then, you didn't even have the protection of the castle law when you were in your dwelling. So in 1979, someone attacked you in your dwelling, you didn't have the castle law to protect you. You only had self-defense. Now you have, in 81, you have the castle law. The legislation, to extend that beyond the dwelling, would give the occupant of the dwelling more rights than the legislature intended to give them by adding Section 8A. And you didn't have even that back 40 years ago.
I had self-defense.
Yes, and you have self-defense outside your house now. But if you're in your house and you see someone outside, you can call the police, and then you have to rely on your rights of self-defense.
Do you think that the local tax authorities considers the porch a dwelling?
A part of the dwelling.
I don't.
It's the tax of the
Perhaps.
dwelling.
I'm not a homeowner, unfortunately.
Let me
But
assure
they-
you, for square footage
Well-
purposes, it includes the dwelling. And I'm simply looking, I understand driveway, right? I understand retreat.
Well, I think we have to look to, again, in other contexts, in other criminal contexts, the way that dwelling has been defined.
I
And the
understand,
legislative.
but I would turn to Justice Glaney's question, is which way do we interpret this in these circumstances? In other words, I understand retreat. You may not be able to retreat, but let's assume you're in a common area. You've still got to go somewhere before you can shut the door.
This court has already decided that the castle law does not apply to in a common area. And that's clear in Albert, that's clear in Fortini and Jefferson, and so all those cases, it's already been, the castle law has already been narrowly...
It's my space, correct?
Right, limited to the inside of your dwelling, the inside, a place where you can go in. And the statute specifically uses the terms occupant and in a dwelling. So if you look at the trespass statute, for example, it's, you could find someone, it's against the law to remain in or upon the dwelling. Upon is very different. Upon a porch is very different from being inside an enclosed area. And
Can I in this case here, I take it the judge also refused to instruct on defensive property?
he did, Your Honor.
He refused to instruct on that.
That's correct. He did. He refused to instruct on that. And although his reasoning for not instructing on that I do not agree with, I believe the ultimate decision not to instruct on defensive property was appropriate. This case was tried on the basis that these victims had gone back to the house to avenge the earlier beating of his son. He was there to attack the defendant or whoever may be responsible for what was done to his son. That was the whole theory of the case. There's no evidence to suggest that the victims were there to go inside to steal the antiques, for example. There was no evidence whatsoever of that. Moreover,
or damage the house, or ransack the house.
Well, there's no evidence of that. Taking the facts in the light most favorable to the defendant, the threat was, if you don't come out, I'm coming in, and someone's going to pay. So he clearly was there to, if you take the facts in the light most favorable to the defendant, to attack people there. To the...
Could I ask you, your brief makes some mention, I don't know what the cases are, that defensive property, you can only use reasonable force, not deadly force. Where does that come from?
I believe that's from an old case, the Clark case from the 1800s. And there is no established in Massachusetts defense of property with deadly force. There just is, that does not exist in Massachusetts. So to the extent that the defendant armed himself with a 4-inch buck knife and a baseball bat, he loses that right to defense of property. He's doing more than what is reasonable in the circumstances to eject a trespasser.
But what if the trespasser's armed? Go to Chief Justice Marshall's hypothetical. You say you can go out onto your porch and you then can reasonably defend your property. But if the people are armed, you cannot arm yourself?
Well, then we're talking about self-defense. The defendant in that case would have the benefit of a self-defense instruction, which clearly contemplates...
What if I go out and point a gun? Right? Get off my porch. They haven't done anything. I look out the window, I think I see a glint of steel in the moonlight. Not sure. I go out and point a gun.
I believe in those circumstances, Your Honor, whether that is reasonable, that would be a question of fact for the jury. Is that reasonable
I've got 3 men on the porch.
Is it reasonable?
Force still has not been applied in the Chief's hypothetical. Once you shoot the gun, then you're applying deadly force.
Yeah, I understand, and I shoot the guy. I say, get off the porch. They don't, and I shoot. Self-defense apply there?
Are you shooting at them? Are you shooting in the air? I mean, again, I think it's a question of reasonableness in the circumstances.
I am alone in a house. There are 3 men on my porch.
I believe in that case,
again, the middle of the night, I'm out in a rural area.
You have, at the moment that they're on the porch and you're on the inside of your dwelling, you have the safety of being inside of your dwelling. Locked doors, you do have 911.
And I can't do anything to get them off the porch.
Well, no, you do. You can do something. I mean, I think you can go out. You can tell them to leave.
And?
You can, and I mean, then there's a plethora of situations that could arise from that. Could you go out with a gun and ask them to leave? Of course you could do that. I mean, I don't think...
And they don't leave.
Again, you have the right to use reasonable force to get people to leave your property in the circumstances.
You can't use deadly force simply to protect property. You can only use deadly force to protect yourself against deadly force.
Correct. If you're in fear that someone's about to kill you, or you're in fear that Someone is about to inflict serious bodily injury upon you. And in this case, there was no evidence of that whatsoever, which is, again, is something that the castle law requires, not just being in a dwelling, both the defendants and the victims, but that the defendant must be in reasonable belief of death or serious bodily injury. And in this case,
was it reasonable belief that someone was about to inflict great bodily injury? All right, so somebody better come out, or I'm coming in, and you're going to pay. I mean, I assume that's a very large man in a group. I assume that could raise that reasonable concern.
Well, no, Your Honor, I disagree with that. I think that that's enough to raise a question of whether he is about to be physically assaulted. The lesser non-deadly force standard in a straight self-defense context. But if you look at the words used in the castle law statute, it's parallel to the words used in the deadly force self-defense instruction, i.e., what a person reasonably has to believe in order to use that deadly force. That is fear of death or serious bodily injury, not just fear of a physical attack.
Or if people stand outside your front door, out on your porch, and they start shooting at you in your house, or if they set fire to your house, they're doing something to you while you're in your house. You may be able, under the castle law, of course you can't retreat under those circumstances, that may just be self-defense, but you may be able to start shooting from within out at people who are attacking you while you are in your house from the outside. You might be able to, under the castle law.
I believe the defendant would potentially be entitled at least to the...
It would be self-defense anyway.
Well, yes.
Just, Luca, could I ask you one question? In response to the defendant's claim that the trespassers had gone onto the stairs and the porch, in your brief you say it's not supported by the record, but would you agree with me that the testimony from Mr. Morley that right before his brother stepped on the first step means that at least there's evidence in the record that they were on the steps?
No, Your Honor, I disagree with that, because right before he's about to step on the first step, or even right before he steps on the first step, doesn't mean that he actually gets there. And it's at that point that the defendant comes out of the house with the knife and the bat. And that is, I just highlight, on page 20 of my brief, I highlight all the points in the record to show that the defendant came out of the house, ran down the stairs of the porch and onto the driveway, which is why I think this case is no different than Commonwealth versus Carlino. But just to highlight...
I know the others. I was looking at the evidence that where Morley says, right before my brother stepped on the first step.
I don't believe that that establishes that they actually made it to the steps before the defendant came out to attack them.
No, I know he came out before that, but that they at some point were on the steps. Right?
I disagree with that interpretation of what the defendant or what the victim said at that point. He said right before he stepped on the step is when the defendant came out, but I don't believe that that establishes that he made it to even the bottom stair, Your Honor.
Okay. Thank you.
Thank you.